Let's go back and understand the words we just learned. So Justice Learned Hand, in the matter of Abercrombie Fitch and Hunting World, laid down these principles of distinctiveness through a spectrum where the fanciful mark was the strongest, the arbitrary coming next, the suggestive, descriptive, and finally generic being not protectable. So we moved from a spectrum of absolutely protectable, easy and strong marks to the weakest and not protectable marks. Coming back to the Indian scenario. Section 9 of the Trademarks Act 99 lists out certain absolute grounds for refusal of registration of trademarks. Essentially, it relates to the intrinsic qualities of the mark. When you say intrinsic qualities, you're looking at the functions that the mark is supposed to satisfy. That is, indicate the origin, the quality, and distinguish the good from other competitors. So this act provides the mark should not be devoid of distinctiveness in the first place. Second, it may serve in the trade to designate the characteristics, the quality or of the goods and services. And in that sense, the intended purpose of the good becomes descriptive. The geographical origin or the time of production of the goods and rendering of such services will be described. And finally, the marks which consist exclusively of marks or indications which have become customary in the current language. So customary words of the trade cannot be used. These are very similar, going back to what are the strong marks, to what are descriptive marks, and to what are generic marks. And like I mentioned before, Indian Trademark Act requires trademarks to be distinctive, non-generic and non-descriptive. Furthermore, absolute grounds for refusal would be when an act also provides marks which will probably not be registrable if they cause confusion in the mind of the public. You must understand a trademark is looked at from the perception of the consumer. The consumer looks to buy a product based on his or her preference, and this preference is essentially an indicator of the goodwill of the trader in the market. So if two goods look similar or appeal to the consumer in a similar fashion, causing confusion in the mind of the consumer, that leads to lack of sales or poorer marketability, and therefore causing this confusion would sometimes be read as deceiving the public. Secondly, if the mark hurts religious sentiments of any class or sections of citizens of India, it will not be a ground for registrability. Further, any scandalous or obscene matter is not protected as a registered trademark. And finally, marks which are statutorily protected under the Emblems and the Names Prevention of Improper Use Act of 1950 ought not to be used as trademarks at all. Shape as a trademark is a typical example within the Indian law, where Section 9 Clause 3C categorically mentions that the shapes of good which result from the nature of the good themselves, or a shape of good which is necessary to obtain a technical result, or perhaps a shape which gives substantial value to the good, cannot be a registered trademark. However, let's visit the trademark rules for a bit and understand that the Indian Trademark Registry's draft manual of trademark practice and procedure provides a contextual framework clarifying the position of whether a shape is really a protectable trademark within the Indian Trademark Act. So when Section 2(1)(m), which describes what a mark is, and it's read with the draft TM manual, it clarifies that certain categories of marks such as shapes, color, sound and smell will require special consideration. What it essentially then means that there is room for judicial reasoning so as to understand whether there is registrability of shape as such in trademark. So far, shape has not been granted as a registrable trademark. However, in the States, a good example would be the Coke bottle. The shape of the Coke bottle is known as a trademark for Coca-Cola. Section 9 of Trademarks Act 99 describes what is non-descriptive words. Non-descriptive words essentially would mean words which are already there in the public domain and cannot be used to have any direct reference to the character or quality of the goods. So in a sense, if there is any word other than an invented word which has to be distinctive in order to be registrable, and finally there cannot be any direct reference to the quality or character of the goods, and finally it must not be laudatory. So in that case, a good example would be to visit and understand what does the court mean by non-descriptive words. In the case of HD Corporation versus Deputy Registrar of Trademarks in 1955, the Calcutta High Court has described that the word rasoi, which in Hindi means essentially a kitchenette, is known to be a descriptive mark when it comes to a cooking oil product. In a sense, the consumer is aware that this product is meant for cooking within the kitchen, and therefore the court held it to be a mark which describes a character and has a direct reference to the character quality of the good which is known to be sold, and was held to be non-registrable. Another example is a geographical name. Geographical indications are essentially a geographical area which are indicating a source of a product of certain value. Section 9(1)(d) explains a geographical name is prohibited from being registered as a trademark. The object of the legislature in not protecting geographical names is to prevent a trader from acquiring a monopoly in the name of a place. That means it might go on to mislead another consumer that the source of the good is essentially that place, because geographical indication is now protected under a separate statute altogether. However, the geographical name can still be granted registration upon evidence of acquired distinctiveness. Acquired distinctiveness, as I mentioned earlier, depends when the trademark is already in the market, is being used, and thereafter the consumer is identifying that trademark through its marketability as having a certain distinctiveness or having a certain quality or a reputation for its own. Example for a geographical name would be Shimla. Shimla is a place, a hill station in India essentially, but the mark Shimla was supposed to be applied for registration for a good such as tobacco, and it was denied any registration for the simple fact that the court held in Imperial Tobacco vs. Registrar again in 1968 that Shimla cannot be protected as a trademark. Other examples or other provisions within Section 9 would be surnames, personal names, etc. Surnames as such or family names as such are not allowed to be protected as trademarks, and they are absolute grounds for refusal of such protection. Prima facie, they are not registrable, however. However, family business can eventually go on to acquire distinctiveness in the minds of the consumer and earn goodwill, and thereafter be registrable. A good example to think of would be probably the famous names of Tata, Ambani. Cadbury also is a good example of a surname essentially enjoying registrability for confectionery products upon evidence of distinctiveness. Further, letters, numerals, such as numerals would be, say, 555 for a detergent powder, or slogans and portraits of traders. For example, MDH Masala has the founding member as the mascot of the product, etc., representing goodwill, may not be registered prima facie, but may be registered upon proof of distinctiveness. And finally, portraits of national leaders such as Mahatma Gandhi or even historical monuments such as Taj Mahal cannot be registered as trademarks under the law. Next, we discuss the relative grounds for refusal of registrability of trademark. Section 11 of the Trademarks Act 99 discusses this. Essentially, it relates to conflicts with earlier trademark rights belonging to third parties. A mark shall not be registered if there is likelihood of confusion and likelihood of association by virtue of its identity with an earlier trademark, or similarity of goods and services caused by such earlier trademark. For example, the Olay body lotion and an OK hair shampoo. Essentially, they both come back to becoming beauty products used by ladies, and if they are deceptively similar to each other, they can go on to confuse the consumer of imperfect recollection or ability to judge the difference between the two goods because of them being identical or similar in many ways. Also, because the class of goods are same and the font, the presentation, the packaging is deceptively similar. So there is a high likelihood of confusion or likelihood of association in that case.